cannot be built on a foundation of lies. And that's, for the purpose of this argument, what I'd like to focus this court's attention to for the purpose of this post-conviction relief appeal. The question I think that before this court today is, what do we expect of attorneys representing individuals or potentially other stakeholders who are presented with and are made aware of exculpatory or favorable evidence or information after someone's convicted, but while they still have time to act? In this case, that's exactly what happened. It appears that Mr. Owens' attorney was made aware, based on the testimony at the post-conviction hearing, of text messages, a substantial number of text messages, which are in the record as exhibit number 13, that demonstrated that two witnesses, including the most important witness, the critical witness, the witness in this trial, the victim in this case, lied about some pretty important issues at the trial. And his attorney did nothing about it. And the issue that we would suggest is an opportunity for this court is to say, what do we expect an attorney to do when faced with that kind of evidence?
That was going to be, what should the attorney have done? I mean, my understanding is they came anonymously. He didn't know from where they came or from whom.
Well,
not really authenticated in any way. So what are you saying the attorney should have done?
the answer can't be nothing. And so there was a number of things that he could have done. He could have reached out. So let me back this up even a step further. And I think there's some confusion about where these messages came from, how they appeared, and what happened between sentencing and, frankly, the post-conviction hearing. And I'll actually say that I think the court's order after the post-conviction hearing, there was some conflict in the testimony, and it never got resolved in the court's post-conviction order. And frankly, I realized it in the last day or so preparing for this argument. And I don't know if that's something, and I'll explain that, and I don't know if that's something this court needs to resolve or not. But though the trial court attorney, Mr. Meeks, testified that he looks at those messages, he knows exactly who those messages are from. They're between the stepmother of the victim and the co-defendant, the mother of the victim. He's like unquestioning that's who those messages are between. He can tell they say Angela on them, the context of the messages. It's 300 pages of messages. It's no small amount. It's not like a handful of messages. It's a huge number of messages. And the context of the message, they're discussing the minor victim. They are, at some point, they're talking about Mr. Owens. I will note that the trial court says there's no discussion of the petitioner. There is a discussion. There's a discussion about his trial. There's a discussion about the victim explicitly. There's really specific stuff. I mean, in those messages, they are talking about being in the courthouse and her testimony, and the mother is saying, let me talk to her. Tell her she's going to do great. You know, sending messages to this girl. And this girl gets up on the stand and says, I haven't talked to my mother in months. I haven't seen her for months. Like, there is very clear sending messages. This stepmother is a intermediary. So the messages are fairly shocking from that perspective. They took a secret trip together 3 weeks before the trial.
And how long after the trial did trial counsel receive those messages?
That's where this gets confusing. Trial counsel at the post-conviction hearing says, I am not really sure that I ever got these messages. I don't recall. He says, I don't recall ever getting these messages. So initially, when this was raised at the post-conviction stage, it was raised as a Brady violation, because candidly, I found them, and the district attorney testified to this, that they were in the district attorney's file, and I found them in the district attorney's file. So they were raised in the post-conviction petitions as a Brady violation. Well, the district attorney got up, kind of surprisingly, got up at the post-conviction hearing and said, wait a minute, no. I gave them to trial counsel. So then there's a conflict, and this is where potentially this court might have to say to the trial court, you've got to resolve this. the district attorney got up at the post-conviction hearing and says, no, I gave these over to trial counsel. I know I did. We had a meeting. I handed him these text messages. I'm sure I gave them over. But trial counsel says, I'm not sure I ever received these.
Pre-trial, or
It would be post-trial. It'd be post-sentencing because of the dates of the text messages. Because they're dated.
so the date of the text messages are after the trial and after sentencing.
They go from before the trial through just after sentencing. So the district attorney likely would have received them about a month after sentencing, maybe 2 months. I'd have to look at the exact dates. But she testified, the district attorney testified, that she gave them over to trial counsel. Trial counsel says, I don't remember getting them. So it was initially raised as a Brady issue, and then at the post-conviction hearing, the district attorney says, no, I gave them over. So at the end of that hearing, I stood up, and this is in the record, and says, well, if he got them, then this is an ineffective assistance of counsel because he didn't file an error quorum nobis, he didn't bring it up at the motion for new trial, he didn't investigate this. There's all sorts of things. He could have called that stepmother who he was in contact with. He could have he could have subpoenaed cell phone records. He could have done 100 things 5 years ago, 6 years ago, at the time that he received those records. In the order that eventually came out from the trial court, he never resolves that issue. Does he believe trial counsel that he never received them and then it's a Brady issue? Or does he believe the district attorney that she gave him over and then it's an ineffective assistance of counsel claim? The language in the court's order is, well, the petitioner didn't prove that these were admissible, and so he didn't prove by clear and convincing evidence that the factual basis for this, and so we don't think it would have changed the outcome of the trial in the case, and so there's no merit to this, which I candidly kind of read as that's kind of post-conviction-y sort of language, and so on appeal I'm raising this as a post-conviction issue, but candidly, as I'm rereading the order, I'm not sure that order is very clear. And so maybe the appropriate thing to do is say, maybe you need to remand this and have the court clarify that factual issue and what actually is the basis, or how do we deal with these text messages? Is this a Brady issue or is this a post-conviction issue? Because there's a conflict in terms of, a factual conflict in terms of when those text messages were received and turned over. But
So you got the district attorney. Did the district attorney call trial counsel as a witness, or were they called by the defendant?
I called trial counsel as a witness. The district attorney called the assistant district attorney as a witness.
And so the district attorney, who maybe representation is the wrong word, but certainly is responsible on the post-conviction relief to try to show there was not ineffective assistance of counsel, contradicted their key witness.
I would say I think they were very concerned about the Brady violation aspect of this. And they didn't want to be saying, no, we held on to these, to me at least, or to the appellant, would appear to be very favorable text messages, that they buried these in their court file and did nothing with them. That they got up there and said, no, we turned them over.
But you said the ADA also testified that she didn't receive them until after trial.
It would have had to be after trial because of the dates on the text messages.
Well, you're making that assumption. Did the district attorney who prosecuted the case testify at all about when they were received and how they were received?
No, she had no specific knowledge or recollection of that. They are dated, so a reasonable inference would have had to be that they would had to have been received after the trial and after sentencing.
Well, you said there were just a really voluminous amount of them. Like what range of dates was?
So the trial was held in March of 2018. The text messages were from approximately November of 2017 through July of 2018. And they're text messages almost daily. So it's 300 pages. They are Exhibit 13 to this hearing. You can look through them. It is a binder full, 300 pages. And somebody printed them. They're not like screenshots. It's a very good representation other than, it's not a specific like extraction like sometimes we see when you have a digital forensics expert. But it's a good printout like from iMessage or something like that.
But we don't know the origin of who they were originally sent to, how they were transmitted.
We don't.
I mean, that's a lot of paper, it sounds like you're talking
Yes.
that nobody has any recollection of
It's-
when or how they got it?
It's paper. The sender is from Angela, and I think there's a number. There may be a number. I'd have to look back at that. My apologies. I don't have it. But it looks like very clearly. And Mr. Meeks, the trial counsel, said without question, this is the stepmother, based on the context and who the names are. It's the
He said he could understand who the messages were between, but he didn't know whether he ever got them.
He never got them specifically directly. They were in the district attorney's office file, and he couldn't recall ever getting them.
Did
That's
the
how he-
trial court make credibility findings concerning either the defendant, trial counsel or the DA?
Never even referenced that they testified about it. It was not even noted. And I think one of the things that's sort of difficult on this is whether it's favorable or exculpatory, like admissibility is not really the issue. There's all kinds of ways something like that could have been used and could have been explored and could have been investigated from a post-conviction standpoint. I mean, there is some case law, Woodson v. State, from this court that admissibility is not really the question on exculpatory evidence questions. And particularly, this was a case where that victim was the only witness who testified that the sexual assault was the defendant. She was the only one.
But the characterization of these text messages doesn't seem exculpatory. It seems like it's impeachment value.
It is impeachment, but that's favorable. I mean, it's really significant impeachment. I mean, it was no question she was lying very significantly about, she got on the stand and she essentially committed perjury. And, that's concerning, where you are the only witness who can connect this charge to this defendant, and you're willing to tell a lie. Maybe several lies. I think that's something the jury deserves to know and should know. And if you know that and then you convict him anyway, then here we are grappling with sufficiency of the evidence. But they didn't know that. And so that's really concerning. I mean, you're right, it's not like here's, somebody else holding the smoking gun. It's not that kind of evidence, but it is it's not small impeachment evidence. It's pretty big. It's pretty big evidence. That kind of a lie would have been really significant in that case. And so I think it's hard to look past it. And there was another witness, her stepmother also testified. She did testify on behalf of the defense, but she told the exact same kind of lies, that there were no, she hadn't been in contact with her mother, she hadn't seen her for months, they weren't in communication. It turns out they were in all this communication. And a big part of the defense was that she was lying and she was covering things up in order to sort of cover for her mother, who was a co-defendant. And when it turns out that these text messages sort of really demonstrated that in a huge sort of way, you don't find evidence like that very often. That's pretty significant.
And so let me just make sure
Yeah.
I'm not confused about the sort of the order of things.
Sure.
And so trial counsel said he doesn't know if he ever got them or not. The dates are such that if he did get them, it was after the sentencing.
Correct.
The assistant district attorney said they had them. Did they testify that they turned them over to trial counsel?
Her testimony specifically is, and I'm going to paraphrase a little bit, but it's pretty close to this. She says, I remember having a meeting before the motion for new trial with trial counsel in the courthouse outside of XYZ courtroom, and I handed him some documents. I believe it was the text messages.
I believe, not I'm sure they were the text messages.
That was it. It was that close.
It's really nobody really can testify for sure that trial counsel ever had them.
Yes,
And
that's correct.
If trial counsel never got them, if he's correct, then are you no longer arguing that he was an ineffective counsel?
Well, I guess I've got a different problem then, in that it probably was a Brady violation.
Yeah, I understand that. I just want to focus it now on the post-conviction. I mean, could he be, render ineffective assistance if he never got these text messages?
No, I guess he couldn't have. It wouldn't be an ineffective assistance if he absolutely never got them on that issue. There are these other smaller issues that I think I've made some argument in terms of the totality of that. But in terms of the text messages, if he never got them, he couldn't have been ineffective on that, and it would just be a Brady issue, which I realize I didn't exactly raise in our briefing here because I think there's some confusion in terms of how do we deal with this conflict in this testimony like that.
The counsel says he may or may not have gotten them. The DA says they may or may not have delivered them.
She testifies that she believes she delivered them. It's not like crystal clear, I've got a record, hear me handing him over and you signing an acknowledgement of receipt, but she...
That would have been helpful, wouldn't it?
It would have been great. We would have, I would have much preferred it, but she believes that she turned him over, is how I read her testimony.
Okay.
And I think that's, you know, like I said, there are some other little issues that the totality of which and the cumulative error was concerning about some things that he, you know, just really didn't aggressively pursue in an ideal world. But these text messages are really the big issue and how we deal with it.
But honestly, at the end of the day, it wasn't the proof that there were multiple images
The images, yes.
depicting the crime for which the defendant was charged and convicted.
Kind of. There were images of a male, but his face was never in them. It was like a penis. And the girl was the only one who could say that was him. So, I mean, that's the issue. Is someone who's...
But they were all on his devices.
Yes, but they were thumbnails. There were all these other images that involved the mother, that were with the mother, that potentially an argument could have been made the mother sent to him. That was never specifically made, but there were other ways this case could have been approached. So nothing that was with him specifically. The only person who could say that was Mr. Owens was the girl. So believing her, someone who was willing to lie, was really at the absolute crux of this case. Thank you. If there's nothing further.
Yes, that's, you can have your rebuttal since we've questioned you so much, whatever it was. So.
That's great. Thank you. Appreciate it.
General Weber.
Good afternoon. May it please the court, Lacey Wilbur on behalf of the state. Your honors, the defendant, the petitioner has not shown he is entitled to post-conviction relief. I just want to confine my arguments to the text messages unless this court has questions outside that. But first I'm going to take a step back and kind of tattle on myself because the post-conviction court's order, it's 22 pages long. He has 5 pages of post-conviction hearing testimony. He's just reciting the testimony. I said in a footnote that was enough for this court. I was not aware of the Tate decision from the Tennessee Supreme Court, which was a remand order that said when there's a question of credibility, you need to send it back for findings of credibility from the post-conviction court. I do not believe there is a credibility issue at all in this court case. So I do believe still, even knowing about the Tate decision, that this court can do a full and complete review because there's no difference in testimony because the petitioner did not testify at the post-conviction hearing to say, I told my attorney to do this, I told him this, he did not do this. What we have is defense counsel said, I did this, 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 and this. And with respect to the text messages, in my brief on page 17, defense counsel is quoted on page 186 of volume 3 saying, I've never seen these before. I never got these. I don't know. And what we have from the prosecutor, Kimberly Lund, her testimony is, again, as he admitted on oral argument just now, she said, I gave him a bunch of stuff after sentencing. I think I gave them to him. That's not a Brady violation, and there's no ineffective assistance of counsel if trial counsel did not know of the existence of these text messages. Bless you.
Excuse me. Thank you.
And looking at the text messages, Your Honor, defense counsel has not pointed to any particular text message within this 310 pages of printouts. We don't know where they came from. They're just printouts, and it just says to and from Angela. But it is clear from a reading of the text messages that it is between the stepmom and the co-defendant biological mother. It's clear. And what they're talking about in these text messages is the stepmother, who the child lives with, says she's not doing her laundry. She stinks. And the mother, responds. The mother talks about, I would like to get her a pair of shoes for Christmas. These are innocuous comments.
Is there more in there, though, that is argued that it shows that there was contact between the child victim and her mother when there was testimony at the trial that didn't occur?
No, what we have is at trial, let me go back up. At the post-conviction hearing, both defense counsel and the prosecutor testified at the post-conviction hearing the victim lied about not having contact with her mother.
So that's undisputed.
And that is not disputed at all. And the trial transcript is archived, so I could not pull it and recite it for you, Your Honors. But both of those attorneys who were present in the courtroom said that was not in dispute, and that the trial court, in its post-conviction order, said at trial, the stepmom said the victim and the co-defendant mother were having contact with each other. Now, the text messages show that they went on for a longer period of time than what was originally thought. But again, there's nothing in there between the victim and the mother. There's one statement where one text from the stepmom's phone says, Mommy, I'm nervous. And the mother says, just tell the truth, baby. That's the only communication we have in these text messages from the co-defendant biological mother and the victim who testified at trial. And just to take a step back, and again, at the larger picture of things, like Your Honor noted, this is not just the victim's word for it. We have images. We have images of a penis in this child's mouth, in this child's hand, in a bathtub. This child testified at trial. My dad took pictures of me. He made me touch his lower part, and he took pictures of me. And there is nothing to dispute that fact, and there is no showing of ineffective assistance of counsel. There's no showing of a Brady violation. These text messages do not entitle the petitioner to relief in post-conviction. Unless this court has any further questions, we ask that you affirm the judgment of the post-conviction court.
Thank you, Trevor. Counsel? Let me make sure I understood what the general said. Of all these, how many pages of text messages, there's only one between the victim and someone.
I am not positive that that's totally accurate, but I will note something about that text message she read. I think that text message is when she's testifying at Mr. Owens' trial. Even though she says tell the truth, significant that she's passing images, possibly in the courthouse, to this girl who says, I haven't talked to my mother for months or longer, I haven't seen her, and that she's up there on the stand saying I haven't talked to her when she's in the hallway texting her mom.
How old is she?
11 or 12 at that time. I mean, I know it's maybe not a big deal, but it's still, there's some deception going on here that's concerning.
But that's the only one for sure, tell the truth, that went between the mom or the stepmom and the victim.
Direct text messages, so far as I know off the top of my head, there are a few other text messages that I think I could just direct Your Honor's attention to, just some references that might be helpful to look at. On page 30 of the text messages, and I think they're Bates numbered, I'm pretty sure. On page 30, it's talking about Grace, who's the minor child, lying so much, lying about everything. Page 62, the stepmother and the mother are coordinating hiding visits from her biological father. There's a number of text messages about that. Page 135 is an example. There's a number of text messages about the stepmother testified at this trial as well. She was a witness. About money, there's constant requests for money, so it's almost like money is deeply involved in this. Page 191 and then 196 through 201 is where the mother is planning to take her biological daughter on a vacation to Boston just a few weeks before the trial. Page 160 through 176 is where the biological mother is planning a secret birthday party for her at a hotel that the biological father doesn't know about. Page 230 through 236 is communications about court and about her court testimony when they're actually in the courthouse. The one other thing I would just note, page 314 is where District Attorney Kimberly Lunn talks about what she provided to trial counsel, and she says, I have a memory of providing something to him outside the General Carney's office, what I believe to be text messages. So she does say she believes them to be the text messages. So there is that factual discrepancy in there that was never resolved by the trial court. So, if there's nothing further.
Thank you, counsel. Thanks to both counsel. Good arguments, good briefs. We'll get it out as soon as we can. Need a break?
I'm good. If you want to break out, Kim.
Waterman, you need a break. Call the next case, please. How much water are you drinking? 100.